Good morning, good afternoon, good evening, depending on your time zone. Welcome to the 8th panel of 11th Annual Cambridge International Law Conference, which is on regulating global economy. My name is Apurva Satpathy. I'm one of the conference staff members, and it's my absolute pleasure to introduce the chair for this session, Professor Lorand Bartels. Professor Bartels is a fellow of Trinity Hall at the University of Cambridge, where he teaches international law, WTO law, and EU law at the Faculty of Law. He was appointed MBE in the 2022 Queen's New Year Honours List for his services to UK trade policy. Professor Bartels is a general editor of the Cambridge International Trade and Economic Law series and an editorial board member of several journals, including the Journal of International Economic Law and the Journal of World Trade and Legal Issues of Economic Integration. Professor Bartels practices in trade law as counsel at Freshfields, and he has advised on WTO and FTA law, as well as on general international law and EU law to a number of countries, NGOs, international organizations, and private sector as well. Professor Bartels has appeared on numerous occasions before parliamentary select committees in the UK, Belgium, as well as European Parliament, and has significant experience in conducting training in trade law for government officials from a range of countries. In 2021, he was appointed the first chair of UK's Trade and Agricultural Commission, advising the government and the parliament on the impact of new FTAs on the maintenance of UK animal and plant health, environmental and animal welfare standards. Clearly, we are in absolute good hands today, and now I pass the floor to you, Professor Bartels.
Apurva, thank you very much. That was a very nice introduction. I don't want to give people the wrong impression that I'm actually the star of this panel. I'm not. I am a humble facilitator, and I, in turn, would like to introduce the stars of this panel. Now, I have to say that unfortunately, one of the people that we were expecting to speak to us on, in fact, global food governance, which does, would have been an extremely interesting talk. There is a paper, you can read that, but she's not able to do this, unfortunately. This is Dr. Mariella de Amstalden, but she had a small, well, there's a reason she's not able to be here today, which is unfortunate. But that gives us more time to hear from our two other panelists. So let me just introduce them and then we can kick off. So our first speaker is Joel Slawotsky, who comes to academia having been a practicing lawyer, including at Dentons, the well-known international law firm. He now teaches at Reichman University in Israel. His focus there is on corporate and economic governance, international economic law, national security, and global governance. And he's taught and lectured at a variety of universities around the world, and obviously, as one would expect, has published widely as well on a variety of topics. Now, Joel is going to be speaking to us today on the following topic: the corporate duty to monitor the state to ensure compliance with international law. Very topical, and there is a case study which Joel will use to flesh out this corporate duty. And the case study is Pfizer's contract with the Israeli government for the COVID-19 mRNA vaccine. There's a lot of healthy goodness in his paper, which ranges across a lot of different fields, a lot of different ways of understanding who might actually be responsible for human rights and who might be responsible for making sure that other actors, in this case, the state, might be responsible for complying with human rights. So it's a really interesting novel take on these questions, and with a highly topical example as well. And I think, in fact, if I could just push forward a little bit in our program, we will be having afterwards Professor Petersmann, whom I will introduce properly when we get to it, but just to say that there is a link actually between what Joel will be talking about, which one can also conceive of in a way as multi-level governance, and what Professor Petersmann will be speaking to us about later on. Our second speaker is Keer Huang, who is a Ph.D. candidate at Wuhan University. She is working in the area of international economic law. Again, focusing in particular on investment law, dispute settlement, and subsidies. And Keer has a topic which is also, dare I say, topical, recent, and it's great actually to see recent events finding their way into academia with barely a heartbeat between them. Her topic, her title of her presentation is Development and Challenges of Global Subsidy Regulation, an International Investment Law Perspective. And the paper is that we're going to be hearing about is an elaboration on a recent development, which is being pioneered by the European Union. But the way these things work, it might not stop there. We might see other international actors, WTO members, and so on, following on with this initiative. And that is to target what are called by the EU foreign subsidies. Of course, all subsidies have some foreign dimension, or you wouldn't be regulating them at all. But foreign subsidies now are taken to mean subsidies, let's say by China, for example, to Chinese investors in the EU. And that raises a whole lot of questions about the gaps that might exist in the WTO subsidies agreement, whether you can use a subsidies agreement to regulate that or not. But that's not going to be the focus of Keer's presentation. Rather, she's going to be looking at this in the context of investment law, because Chinese investors in the EU are investors and should be protected under investment rules. And so we're going to be hearing about the EU's efforts to target foreign investors in its territory and what that might mean, I think both from a subsidies perspective and also from the investment law perspective. So it's a really good interface between different regimes in the area of international economic law. So we've got two very interesting topics to keep us entertained and educated for the next hour. Because we have two speakers, they have an unusual privilege when it comes to conferences, which is not a great deal of pressure to cede the microphone to the next speaker. So this hopefully is going to be a privilege exploited to the fullest, but we will still, of course, have time after their presentations for Q&A. I think there's a lot in these presentations, so hopefully that will provide an inspiration to you, the audience, to type away into the Q&A box, and we can have a good discussion after that, before we conclude the conference with the keynote address of Professor Petersmann. Well, with that, let me now hand over to our first speaker, Joel Slawotsky. The floor is yours.
Thank you so much, Lorand. And Lorand, you are a star. Let me pull the PowerPoint. You can see the PowerPoint, I presume? Can you guys see the PowerPoint?
No, I don't see it.
No problem. I will technical. Can you see it now?
Yeah, thank you.
Okay, good. You're welcome. Okay, so this is going to be a discussion. I'm going to try to limit it to, I know I have a few extra minutes. I'll try to limit it to approximately 20 minutes, but of course, I guess there's a little bit of discretion on the part of Judge Bartels. Anyway, the topic is, as Lorand had mentioned, is the corporate duty to monitor the state to ensure compliance with international law. And this is going to be a discussion of how human rights can be ensured, in a sense, not through state ordering or states monitoring, but rather perhaps should be also more emphasis on a corporate duty. And in recent years, just as an introduction, there's been an increasing focus, as we know, on the question of corporate liability and complicity. Larry Backer has done a fantastic job, as many others have done also, and he had a fantastic post at his blog, Law at the End of the Day, which I read quite often, on corporate responsibility in the context of the Russian invasion of the Ukraine. And the conceptualization of corporate liability is essentially states having the duty to ensure corporations do not engage in human rights abuses. And it's really a focus on regulating corporate conduct and on enabling, empowering domestic courts to rule that corporations can have liability. And this is important. State monitoring of businesses is important, was important, and it will remain important. However, I believe, and I suggest, and I will try to convince all of you, if you're not already convinced, that the duty also should be looked at more specifically at corporations monitoring the state to make sure that human rights abuses don't take place. And there's really several reasons, but the two main reasons to examine this approach is, number one, of course, multinational corporations are powerful actors. They have significant economic leverage in the political economy. And they can therefore use their influence for good. Unfortunately, they can also use it for not so good. And number two, given the need to tackle global problems which are coming to the surface, poverty alleviation, climate, pandemics such as COVID-19, there is a likelihood of greater corporate and private corporate and state partnerships going forward. And why is this context? I'm going to use the Pfizer-Israel collaboration. Why is this important? Because it was not merely a procurement contract. It was also significantly, as set out in the actual draft paper, it is a collaboration on data. The actual contract between the US pharmaceutical Pfizer and the Israeli government refers to itself as the project and data collection. So they are really collaborating on data, and it brings the corporate duty into sharper focus. And we're going to look at what possible obligations did Pfizer possibly have with respect to safeguarding human rights. Let's get straight to the actual contract. So this is a contract, data collaboration and relationship. The contract itself, as I mentioned a minute ago, refers to itself as the project. Initially, and this is, I think, very important, the Israeli government adamantly initially refused to disclose the contract. And it was reported in the media that the government, one of the specific, the health minister basically said that releasing the details of the contract would be, quote unquote, criminal. Furthermore, the third point I want to make is that nowhere in this contract, now they eventually did release a redacted version, which we're going to get to, but initially they refused to release it. Number three, nowhere in this contract is informed consent mentioned, notwithstanding the fact that Pfizer insists on Israeli governmental compliance with the US Foreign Corrupt Practices Act, the anti-corruption law, anti-bribery. Now, there was intense media pressure within Israel to release the contract, and they finally did release a very, very heavily redacted contract. You can look at it, it's freely available on the internet, but you could see that it is extremely well censored. And if you read it, it seems to be more than just a procurement contract. It certainly is a collaboration agreement on data. And it's perhaps a little bit more than that as well, because statements from both the CEO of Pfizer as well as the former Israeli prime minister seem to indicate that they both parties intended that this agreement would essentially be an experiment, and that the Israeli citizenry would serve as a laboratory. Even though it doesn't specifically say that in the contract, one can arguably say that it's certainly implied. Now let's take a look at the implementation of the vaccination program. The vaccination program and the issue of informed consent. The Israeli vaccination program was very, very heavily marketed within Israel. There were announcements everywhere. The former prime minister, and this is actually, you could see this on YouTube, actually had a really interesting commercial basically saying that it was very safe, it was approved by the Americans, and then they had some clown guy, some comical guy come up and say, But you know, but Bibi, we heard that if you take the vaccine, you're going to grow a third hand. And he says to them, "Oh, don't be a clown. It's completely safe." Something to that effect. Which again, you know, is pressure, because it basically is saying that it is 100% safe. The FDA fact sheet explicitly stated at the time that this is essentially all the adverse effects are unknown. And this fact sheet was not noted or provided either in Hebrew or in English, nor was it widely communicated. Now, I'm sure that the response of the Israeli government would be, well, you can kind of look it up, on the internet, but I'm not so sure how many people are going to bother to look that up. And the HMOs, the health maintenance organizations, the Kupat Cholim, they also said they had this very, very strong marketing campaign. Health officials saying that this Pfizer COVID-19 mRNA vaccine is the only way that will allow us to resume our normal lives, without any mention of anything else, such as alternative vaccines that were manufactured, for example, by China, which were not mRNA vaccines. I also believe India might have had a vaccine as well. I spoke with somebody from India who told me that he believes that the vaccine he took was not. The bottom line was that the claim that this is the only way to vaccinate was not exactly 100% correct. And there were also a lot of negative pressures that the Israeli government brought, including claims that they were going to, this did not pass the Knesset, the parliament, but that they were going to give, the government was going to give access to the Israeli Ravacha, the welfare department, and the education department, access to information showing who did not take the vaccine and who did not have their children vaccinated, which clearly is a form of negative pressure, because it's known that they are heavy-handed and they will accuse you of child abuse for not vaccinating. So it's kind of a negative pressure. Again, as I mentioned, the Pfizer mRNA was portrayed as the only cure. The Chinese Sinopharm and the other one was not mentioned as non-mRNA alternative vaccines. So Israeli citizens were essentially not provided this option. For them, bottom line, it was the only way out, because there was no other vaccines that were made available. But the problem is that they were kind of led to believe that that was the only vaccine in the world. Anyway, informed consent. An important question, obviously, is whether the Israeli government complied with informed consent. By the way, I am not saying that these vaccines are not healthy, they're not okay. I'm not saying in any way, shape, or form that they are dangerous. I'm not saying that at all. What I am saying is that even in emergencies, states need to comply with informed consent. And that's going to be the bottom line, because even in an emergency, perhaps even more so, it's a slippery slope. We have to ensure that human rights are followed, and we cannot shirk informed consent because it sounds like it's, who cares about informed consent? It's a serious human right. We know the Nuremberg Code, the Declaration of Helsinki, World Medical Association. Again, I'm not going to spend time. I think most people here know about this, the importance of it. ICCPR, again, Article 7 in particular, no one shall be subjected without his free consent to medical or scientific treatment. I think this is really also very, very relevant. The World Health Organization, International Health Regulations, it's not on here. I believe it's Article 23, subsection 3 and subsection 4, if I'm not mistaken. In terms of, in the context of an emergency, no medical examination, vaccination, etc., shall be carried out without their prior express consent or that of their parents or guardians. In other words, even in an emergency, who says you must maintain informed consent? Do not vaccinate people without having them informed. And again, informed consent basically means, and it's written out in the draft, basically people have to know what their choices are. People have to be informed. People need to be able to arrive at a good decision. There was a advertisement many years ago from Sims Clothing, an educated consumer is the best customer. I think it's the same concept. People need to be informed. People need to know in order to make a decision whether it's best for them or not best for them. And when there's no informed consent, it's dangerous. Now, did the Israeli vaccination program comport with informed consent? And what's the deal with Pfizer? Well, I believe that there are serious questions whether the Israeli government complied with the international law obligation of informed consent. I believe several factors militate in favor of saying that the answer is no. Number one, obviously, there was an initial refusal to disclose the contract. It's now been published in redacted form. Well, I think full transparency is vital. The core of possible conflicts of interest and its interrelation with a lack of informed consent is clear, is manifestly clear. I have no idea, and I'm not saying it's true, but nobody has any idea whether the redacted parts of the contract state something to the effect of, if the Israeli government succeeds in getting a certain percentage of its population vaccinated, then the price will go down or the government will receive something in return. We have no idea. Well, I'd like to know. Then we need complete disclosure in order to determine that. I think the fact that the Israeli government declared its intent to vaccinate the entire population is also extremely significant because it might incentivize an overly zealous implementation of the contract. The fact that the FDA fact sheet, which advised that adverse effects are unknown, was not provided, I think is also something very important. And I'll just go through this quickly because I do want to keep into my 20 minutes. And I know there's a little flexibility, but I'd like to keep with it. So I'm going to try to move a little bit faster. I think there really is a problem in terms of the negative pressure as well. I think the fact that the alternative vaccines were not so much that they were not made available, but that the population was not even advised that they were available potentially. I think that also is a problem. There also is, and I'm not going to go through it, WHO had said don't vaccinate pregnant women, even though they retracted it at the time that the advice was not to vaccinate pregnant women. The Israeli government proceeded very, very aggressively to recommend pregnant women get vaccinated. The same thing with children. So I think there's a problem. So presuming arguendo that the mass vaccination program failed to obtain the informed consent, let's presume that there really is a problem. Who is responsible? Well, let's get to the heart of this. Traditionally, there's been state monitoring of corporations, as we've discussed. The guiding principles we all know about. The classic actors in international law have been states, and unsurprisingly, the conceptualization, as I mentioned at the very beginning, of imposing corporate liability is basically on states regulating corporations and empowering courts, and it's really focusing on corporations being responsible for making sure that they don't do something improper. And again, I think that's going to continue. However, I think that we have to look at corporations monitoring of states. I think that corporations should have a heightened responsibility, particularly when there's a collaboration between a corporation and a state. And we can just look at, and the guiding principles had mentioned business relationships and with any other non-state or state entity. I think obviously if it's with the state as well, and the responsibility of business enterprises from Friends of the Earth, it is not enough for businesses to monitor developments and follow the measures states take. They have an individual responsibility. And let's take a look at this. This is from Larry Katabacker. He wrote, states can use procurement as a means of providing models for contractual provisions. Well, corporations can do the same thing. There is nothing wrong, and in fact, there really should be an obligation on corporations to negotiate and put in to their procurement contracts with states human rights compliance language. There's no reason why they should not be doing so. And in fact, I'm going to do this very, very fast. We're getting towards the last 6 or 7 slides, I believe. But let me just move along to give ample time for Keer and for discussions and questions. This also kind of meshes and it jives with, it comports with the heightened duties on directors in Delaware, the whole trend of ESG. For those of you who are not familiar, there was a landmark decision in 2019 from the Chief Justice Leo Strine. He authored it in March, and basically saying that directors not only have a duty to oversee and have monitoring in place, but they have a duty to consistently monitor the mechanism to make sure that it is working well. And I think while Marchand dealt with food, the same reasoning is applicable to the pharmaceutical industry and upholding international law, particularly when the health of the public is at risk. Therefore, Pfizer, I believe that Pfizer should have, and they did not. Did Pfizer evaluate the business relationship for human rights issue? There is no indication that Pfizer insisted that the Israeli government comply with informed consent. The contract could have included language such as compliance with the FCPA. They could have embedded into the contract a mechanism to ensure compliance and reporting to Pfizer. This could have been very, very easy. Remember, they're doing data collection. If they're doing data collection and they're asking the Israeli government to report how many people are being vaccinated, what their ages are, and so on and so forth, how difficult could it be to add a checkbox there that says, have you made sure that the person receiving the vaccine was informed? Did you obtain their consent as international law requires? That would have been nothing with nothing to add that to the contract, and they obviously didn't. So in conclusion, a suggested path forward is that corporate liability for human rights violations, while it has been tackled from the perspective of viewing corporations as the entities which need to be monitored, I would suggest that in view of the strength of corporations, in view of health emergencies, climate change, poverty alleviation, that focusing on enforcement of global norms through the lens of state monitoring of corporations should not be the only way. We should also be looking at how corporations can monitor the state. They are in the position to do so. They've got influence with states, and they should be able to influence states. So there's three overarching themes of responsibility. The corporation must perform due diligence to identify potential human rights impacts with the state. Two, they must also ensure that its partners uphold international law. This could be accomplished by inserting contractual provisions with the state. And three, I think if you look at Marchand, you really get this idea that corporations must have a continuous obligation to assess human rights problems, which logically includes monitoring to ensure that any failures will be flagged and subsequently remedied. Again, I think it would be very easy to just put this type of thing into the contract between Pfizer and Israel. I don't see why they couldn't have done it. And I think that and I'm finishing up, this is the last slide. Obviously, in any government procurement contract between a corporation and a state, this can be done, but I think that the duty is even more enhanced when you have a collaboration. As a collaborator, the duty is even more pronounced to ensure some oversight or monitoring. Pfizer was really engaged in a collaboration with the Israeli government, and they just completely ignored the international law norm of informed consent. Anyway, thank you very much. Thank you, and it was great having a few extra minutes to go a little bit further and go slower. Thank you very much.
Well, thank you. That was really fascinating, and I'm sure that we're going to have a good discussion about what you were saying at the end of the next presentation. So everybody who is online, please do formulate your questions and pop them in the Q&A box, which presumably you can find on Zoom. Now, we move straight to Keer Huang, who, as I mentioned before, will be speaking to us about foreign subsidy control and in particular how that relates to international Investment law. So a topic of great interest. I hand the floor to you, Keer.
Thank you, Prof. Bartels. Just to confirm, can you see the slides?
Yep, we got it.
Okay, thank you. Well, thanks for the organization and your kind introduction, and I really appreciate the privilege of time extension. My presentation, the topic of my presentation today is about development and challenges of global subsidy governance and international investment law perspective. And there's a quick roadmap for my presentation. First, I'll briefly introduce the background, and then I'll provide a general definition of foreign investment subsidies. After that, I'll move to the development of global subsidy regulation, as well as challenges resulting from regulation of foreign investment subsidies, and finally provide a conclusion. So, concerns to subsidies in international economic activities are far from new. Countries may use subsidies for various reasons, including overcoming market failures, encouraging certain sectors, evening out regional disparities, and so on. In the context of economic globalization, where production occurs in the global value chains, it is more necessary to set limitations on countries' subsidization activities for the purpose of preventing inadequate economic interventions. And the current multilateral framework for subsidy regulation, as we know, has been built by WTO rules since last century. And the ASEAN agreement focuses on subsidies that benefit the production of goods and cultivating measures in response. Well, as Professor Bartels mentioned earlier, WTO rules on subsidies are not the major focus of my presentation today. And instead, the background of my paper is closely related to the emergence of foreign investment subsidies and relevant regulatory measures, which has been revealed in recent rules such as the CBTBT, the EU-UK Trade and Cooperation Agreement, and the EU's new move on foreign subsidies, etc. In recent news, it can be observed that the field of application of rules on subsidies has been expanded from trade of goods to service trade and investment. As you can see from the picture on the slides, according to the database of OECD, from 2005 to 2020, the ratio of global outward FDI stocks relative to global GDP has almost doubled from about 25% to 46%. And with the growth of our FDI stocks, countries have introduced various home country measures, which we call SCM here, for their outward investments. As one of the most significant FCMs, foreign investment subsidies exist, with discussions on whether such subsidies from the home state convey unfair advantages to their outward investments, and in this manner constitute a threat to a level playing field. Consequently, countries take actions to regulate foreign investment subsidies, and from trade subsidies to foreign investment subsidies, we can see the development of global subsidy regulation, both rules and practice. And meanwhile, there are challenges existing, especially in the regulation of foreign investment subsidies. Before discussing the developments and the challenges, I'd like to define the term foreign investment subsidies at first. As the slide shows, the term foreign investment subsidies refers to a financial contribution, which is granted directly or indirectly by the home state for the purpose of facilitating, supporting, or promoting an investment in the host state, and which confers a benefit to such investment. And such subsidies are limited in order or in fact to certain undertakings or industries. Regarding the effect, foreign investment subsidies may not only have an impact on the competition environment of the host state, but also affect the competition environment of the third state with which the investor has economic relations and even the global competition environment. For example, in the United States Innovation and Competition Act of 2021, and the Act emphasized that subsidies from certain countries had had a negative impact on the global markets, which will lead to depressed competition around the world, reduced opportunity, and even harm to both producers and consumers. Moreover, it is notable that foreign investment subsidies should be distinguished from other terms. The first one is the domestic investment subsidies, which are granted by the host state of the FDI, and with the purpose of supporting certain centers, assisting regional development, or pursuing other public interests. And such subsidies differ greatly from foreign investment subsidies on both the subsidy providers and the purpose of granting subsidies. The second one is the transnational subsidies, which are repeatedly discussed in the recent researches, and these subsidies are confirmed by a country that is not the country in which the class or kind of merchandise is produced, exported, or sold for importation into the third country. Overall, the transnational subsidies focus on subsidies for production of goods, while foreign investment subsidies include subsidies for investments with respect to offering both goods and services. So, regarding the development of global subsidy regulation, there are three main aspects in my paper that the aspects can be observed in recent rules and practice. And the first one is about the coverage of goods. As we know, the Article 1 of the CILJ agreement provides the definition of subsidy with three basic elements. The first is the financial contribution, and the second is the subsidy granted by a government or any public body within the territory of the country. And the third one is the subsidy which confers a benefit. And also, Article 2 of the CILJ agreement states that for a subsidy to be specific, it needs to be given to certain enterprise or industries within the jurisdiction of the granting authority, except if that subsidy is a prohibited subsidy. However, in comparison, recent rules in practice, we can see that the coverage of rules on subsidies has been expanded from two perspectives, at least from two perspectives. First, we can see that the subsidy providers are no longer limited to a government or any public body under the WTO rules, and accordingly, SOEs like the state or banks might be classified as subsidy providers. And more importantly, the location of subsidy recipients is not limited within the territory limits of the country that grants subsidies, which has been seen in their practice like the glass fiber fabric cases, which is the countervailing measures taken by EU. And in that case, the EU imposed countervailing measures against subsidies provided by Chinese government to its outward investment in Egypt. And the second is about transparency requirement. Without transparency, rules on subsidies and countervailing measures are just words on paper. And in the past 2 decades, the transparency mechanism of WTO legal framework has been criticized for its underperformance and ineffectiveness. According to the report of WTO in 2020, out of 164 members, only 42 of them provided notification on subsidies they have been acted. So, facing with that problem, recent rules on subsidies enhance the transparency requirements by several approaches. For example, the EU-UK Trade and Cooperation Agreement strengthens the disclosure requirements, and the EU proposal imposed disclosure responsibilities to certain subsidy recipients, like the undertakings concerned in the constitutions. In addition, the joint statement of Japan, US, and the EU suggested to prohibit any non-notified subsidies that were counter-notified by another WTO member, unless the subsidy provider country provides the required information within the set timeframes. Moreover, recent rules have developed the diversified procedures to address conflicts concerning subsidy regulation. There are procedures like the conciliation proceedings and the remedial tool to order recovery when a country make an error on road in cases concerning subsidies. As we can see so far, existing rules for foreign investment subsidies can be divided into 2 categories. One is included in the WTO multilateral framework, and the other is recent rules that I have mentioned earlier, which partly depart from the traditional rules on the coverage of transparency and dispute settlement. And as for the first category, we can see that on the one hand, the SCN agreement can potentially be used to adjust foreign investment subsidies, but only for the production, but only for subsidies for production of the goods. And on the other hand, although the gaps provides no disciplines on service subsidies and countervailing measures against foreign investment subsidies into service providers would be allowed only insofar as they do not violate the non-discrimination provisions or if they are justified under the exception clause. And regulatory rules on foreign business subsidies raise new questions, not only in WTO law, but international investment law. When we look at the current investment agreements from network, we can see that few treaties have established rules concerning subsidization policies of host states, while rules on foreign investment subsidies from the home state remain nearly blank in existing treaties. As such, two questions remain unanswered. First, whether disputes regarding regulation of foreign investment subsidies should be insulated from investor-state dispute settlement. And currently, in some treaties like the draft tie between the EU and China, and disputes concerning subsidies were excluded from the application of dispute settlement chapter, while the contracted parties should consult in an effort to reach a mutual solution if a subsidy has or could have negative effect on one party's investment interest. Well, given the paralyzed WTO updated and this paper believe that as this might provide another avenue to address disputes concerning regulation on foreign investment subsidies. And the second one is about the interaction between the rules on foreign investment subsidies and existing IAs. Unilateral regulatory measures with country-specific concerns might result in doubts on the IA capability. Taking the EU's move as an example, in the proposal for foreign subsidies, the EU pointed out the existing regulatory gap to address distortions in the internal market caused by foreign subsidies. However, it remains to be seen whether the extension of EU state aid rules to foreign investment subsidies is non-discriminatory. Currently, it appears that the difference between these two systems, between the EU state aid system and the foreign investment subsidy rules, like the inclusion, like the lack of wide leaks, or to say the broad extension regulations of in the proposal, and the notification responsibility of certain foreign investment subsidy recipient. And this kind of difference might go counter to the national treatment provided under the international investment agreements. And meanwhile, states that impose countervailing measures may also defend themselves with exception clause, like the schools that we discussed under the gaps, and they may concerned with about the security exception and general exception. So to briefly conclude, in global subsidy regulation, rules on foreign investment subsidies trigger not only WTO law but international investment law concerns. And during the rulemaking process, attention should be paid to enhancing the coherence between host states covering policies and the existing IA network. Well, in the long term, countries are expected to work in a more coordinated way to address foreign investment subsidies, either by reforming WTO rules on subsidies or developing a new approach independent from the existing legal framework. And that concludes my presentation. Thank you for listening.
Well, thank you very much. That was really very interesting. Again, I'd like to invite our participants, the audience online, to put your questions in the Q&A box so that we can run through them. We already have a question. I'll read it out. I don't know if everybody can see it actually, but I'll read it out anyway. Josefa Franke from the Hans Bredau Institute in Hamburg. I'll just read it out, but Joel, I think you could probably say this is for you. Where do you see the grounds for assuming businesses' responsibility? Is it a mere moral obligation? And if there was to emerge a legal obligation, will there not be a backlash by private entities on the separation of the private and public and excessive regulation resulting in business having to bear the state's original obligations?
Hi, I think that's a great question. Okay, a couple of things. One, I don't think we should really discuss the moral obligation. I think it's really a corporate, I mean, there's an international law norm of informed consent. I think the bottom line is that a corporation that is empowered to ensure compliance with international law has a duty to do so. I think it's a legal, I would like to look at it as a legal duty. When we start to talk about morals and ethics, it becomes a little bit more iffy. Let me, if I might, let me give an example. I think a lot of people are really into ESG, stakeholder corporate governance. I actually was teaching this last week in my global business law course, and we were discussing the whole idea of how does a corporation balance various stakeholders? And the truth is, I think it's very difficult because, for example, let's say a corporation wants to help consumers, they want to lower prices. That sounds good, but obviously that will be inimical to shareholders who are going to lose. But it is also going to be, it might very well be inimical to another stakeholder, the environment. Perhaps they're going to cut corners environmentally in order to bring the price of the product lower. And I can also look at it in terms of diversity, gender diversity, racial diversity. For example, what if a corporation's directors and a stakeholder or an enhanced shareholder value, I know UK since 2006, it's kind of that middle ground, the enhanced shareholder value. Let's say the directors say we are going to try to bring diversity to the board, and we are going to bring more women on the board. And again, I don't think anybody here is against, in principle, diversity. I think it's good. I think most people would agree that that's a sign of strength. The issue is when you try to become diverse, you might also, if you're not doing it in the right way. For example, if you're using quotas, which are obviously after Bakke in the US, and that's kind of like something you can't do. But if you use quotas or if you use some strong measures, you're going to be hurting other groups. For example, let's say you hire women and most of the women applicants are Black women as opposed to Latino women. Well, then the Latino women are going to be underrepresented. And what about Black males? Men are going to be underrepresented. So when you start to have these stakeholder interests, it really is very, very difficult. And therefore, going back to this idea of corporations and losing money, absolutely. I don't think corporations are in the business of losing money. They should not be. I think we all can see that private enterprise is actually a very effective model. Even the Chinese, even though it's called the Chinese Communist Party, it's a capitalist economy. It's a state-centric capitalist model. They abandoned communism. I mean, communism, obviously we all know, sounds good. Everybody gets the same amount, but it doesn't practically work out. So I don't think that the corporation should be, morally responsible, but it is following the law. And I think that there should be some sort of legal liability if, for example, the state violates human rights, causes damages, and the corporation, which was in a partnership with them, could have eliminated that problem or at least attempted to reduce it. I'm not against corporations making money. I think they obviously need to make money. And if they're not making money, I think it's going to cause an economic, it's not good for the economy. Companies need to make money. The question is, it's always, it's a balance. It's a balancing act. Thank you for that question.
Well, thank you very much, and also for the answer. I have a question for Keer, which I would read out to you so that the participants can hear it as well. So the question is, this is from Zhuyun Guan. Does state subsidy scrutiny, does this regulation only apply to private, which is to say non-state-owned companies, or I guess does it also apply to state-owned enterprises?
Yes, thank you, Professor, and thanks for the question. My answer is no, and yes, as for the regulation, the application of regulation, it depends on the different international economic agreements. Exactly, if we look at the CBTT, like the Chapter 17, it's about it discusses the state, the state companies as well as the SOEs. And if we look at the regulation, we will focus on whether this enterprise provide for non-commercial assistance, and they didn't use the term subsidy directly. Well, if you look at other, like the EU proposal which I mentioned earlier, and it had set limitations, had set different standards for the regulation for the enterprise. And if an enterprise or a company and reach that kind of standard, whatever there's a private company or there's a SOE, you might fall within the regulatory scope of the proposal. And especially when this kind of enterprise or undertakings participating in the concentrations and in the internal market of the EU. Thank you.
Thank you very much. So I have a follow-up question for you, Keer, if I use my privilege as chair. I wanted to ask you a little bit more about what it is you think that the host states are likely to be doing to the foreign investors in their jurisdiction that would actually be a problem for investment law. I mean, are they planning to nullify the value of the investment? Presumably they're not going to go as far as expropriate it. Do you see it in terms of discrimination? What are the actual problems, do you think?
I think we can divide the question into two phases, like the post-investment phase and as well as the pre-investment phase. In the pre-investment phase, and a lot of in the recent investment agreements and the national treatment, the application of national treatment obligation has extended to that kind of base, and so the market sales is also a prerogative of the is also a prerogative of the investors who want to go to invest in other countries like in EU or in the Americans. Well, this kind of regulation is like the subsidy is similar to for example, the security, the national security agreement, and they may set a limitation for certain foreign investments instead of all kinds of the foreign investments, but with perhaps with country-specific concerns, and that may constitute the discrimination for investors at the pre-investment phase. And the second part is about the post-investment phase, when investors start their investment in the host state, and the entities begin to rent. And in that kind of process, that might the rules on the foreign investment subsidies, especially the EU. The EU proposal, if we look at into the text, they have divided into three models, and some of them is exactly targeted at the post-investment faces. So, and this might like to some extent, they although there's no cases so far, but it has the possibility that the kind of regulation and the measures calculating for the for investment subsidies might constitute an expropriation.
Okay.
Yeah, how I answer the question? Yeah.
Yeah. No. Thank you very much. That's it's really very interesting. I also have a question for Joel, and it's a really fascinating take on. I mean, there's different ways of looking at it, but let's say business and human rights as a sort of overall framework for understanding what's going on. I mean, you layer this in a really interesting way, and of course, the case study is really quite fascinating. Now, I'm just wondering if I can ask you a little bit more about the nature of the human rights obligation, which you say Pfizer, in your example, would be subjected to. Do you see this as being something which is binding on a private actor like Pfizer directly under international law, or do you see this as being mediated through domestic law? You quote the Canadian case, for instance. I think that was an example of domestic law. So the Shell case was a tort case in Holland. Vedanta, of course, was tort as well. So it is possible, of course, to bring human rights due diligence type obligations into domestic legal systems, either directly if that's what the legal system allows, or you do it via essentially negligence claim. And you can also, of course, run it through director's duties, which is, I think, the American analogy. And there is a lot of interesting development there in the jurisdictions that I am more familiar with. So I'm just wondering what your take is on this. Do you see it as a sort of direct thing, or is it mediated through domestic legal systems?
That's a fantastic question. I think we can draw a little bit of an analogy from the Alien Tort Statute litigation in the United States, which I think you've alluded to, and I think it makes a lot of sense. For those of you who are not familiar with it, many of you obviously are, the Alien Tort Statute enables aliens, non-U.S. citizens, to file claims in U.S. federal court for violations of international law. Now, interestingly, Pfizer itself was sued back in the early 2000s for performing for providing a drug to children in Nigeria without providing informed consent. And the Second Circuit actually, and the case was eventually settled, but the Second Circuit said that Pfizer had a responsibility. In that case, they not only aided and abetted, they actually sent their own doctors. So I think it was more of a direct liability and or aiding and abetting complicity. Now, interestingly, the courts in the United States have cut this back quite extensively, kind of like a counter trend, because as you mentioned in Canada, the Nevson case, which basically said that corporations can have liability, domestic corporations can have liability. Friends of the Earth, the clear trend around the world in enlightened jurisdictions is to hold corporations' feet to the fire, not only for themselves, but also for supply lines. In the United States, the Alien Tort Statute has been cut back. The Second Circuit actually stated after the Pfizer case, back in the Kiabel case in 2010, that corporations cannot be liable because they are not actors in international law. It was a 2-to-1. Judge LaValle dissented, if I recall correctly, Cabranes, and don't remember who the second judge was. It was a majority. And they said that the directors could be liable. The officers and the directors, as you mentioned, as a possible route, that the directors and the officers could be potentially liable for a violation of international law, but the corporation itself could not be. To date, that is the only circuit that has said that. Every other circuit does allow corporate liability. As you all know, as for sure you know, the Supreme Court has used the presumption against extraterritoriality to cut back. They never really answered the question, although in the most recent case, Nestle, which was the child labor case out of the Ivory Coast for cocoa, it was very interesting. All of the justices spoke about presumption. It was basically, that's why they dismissed the case. But a majority, plurality of the justices would agree that corporations can have potential liability, which comports with the global trend. So the short answer, well, I gave that background. So my answer would be, I think it obviously depends upon the jurisdiction. I think that in the United States, it would be, it could be used by potentially Israeli citizens if they were damaged, if there was long-term damage. Hopefully there won't be, but if they were damaged, if they will be in 5 years, they will have an immune problem. And let's say they find out that mRNA is dangerous or causes problems, I think they would be able to file claims in US federal court under the Alien Tort Statute and basically say, Pfizer, you aided and abetted. You didn't act yourself, you didn't act directly, you didn't vaccinate anybody, but you aided and abetted the Israeli government's failure to comply with international law, and therefore you owe us damages. Hopefully it won't happen, but I think that would be one venue. I don't want to use up all the time either, so there might be somebody else, but that's how I would look at it. Depends upon the jurisdiction. You have to unmute yourself.
Sorry about that, everybody. I was just saying that's really very fascinating, and we'll see how it evolves. And I think you've really hit on a great case study there. Now, I have another question for you. This one is from an anonymous attendee, but of course, there is no need to be shy. But who knows? The question is as follows. Again, to Joel. This may be a bit off from the paper that you presented, but could you please elaborate a bit on what you think of the roles of international organizations in monitoring and ensuring state compliance in international law? And of course, I guess, yeah, the WHO is probably front and center with the sort of human rights we're talking about.
Yeah, precisely. That's another great question. You know, poor Keer, it's Yishen La in China. It's quite late there. Yes, I speak a little Chinese. When you're there, you pick it up a bit. Yeah, I mean, I think clearly that the WHO is. I mean, I think personally that their statement on vaccinations, and I think it's Article 23, Section 3 and 4, if I'm not mistaken. I think that they have an important role to play, and I think here you have an expert organization that is ostensibly doing things that are in favor of the public's health globally. And I think they have an important role to play because, presuming correctly that they are filled with experts and they're objective, then we should pay credence to them. And I think they do have a role to play. But again, I think the bottom line is financial incentives, financial disincentives are very, very important. Corporations are responsible, they have responsibilities. And, you know, it's not just about a moral question, it's a question of profits. If Pfizer is going to get damaged later on because they've acted improperly, because they broke the law, then the directors should clearly not want that behavior to go on. And there should be mechanisms in place to make sure that corporate losses do not materialize. But again, just going back to what Laura had mentioned in terms of when we're talking about the Alien Tort Statute, I mean, Pfizer actually did something bad in Nigeria. And I must say that pharmaceutical companies sometimes, you know, even if there's an FDA approval, go back 15 years, remember Merck, the example of Merck, they produced Vioxx, which was a pill to help older people do sports for arthritis. It had FDA approval. This was 15 years ago, 16 years ago, and it was eventually recalled and they had to settle for billions of dollars. And there was evidence from discovery that they knew full well as they were marketing it that Vioxx was dangerous, but they continued to sell it. I mean, that's not just a moral problem, that's a financial problem.
Thank you very much. Yeah, I have another question, which is also for Joel, but actually I think I want to ask a question of Keer for the sake of parity, but also because I'm interested and probably others will also be interested. It's probably a novel topic for a lot of people. So my question to you, Keer, would be, I wonder if you could say a little bit about the background to the topic of foreign subsidies as a problem, right? So predominantly at this stage, it's China, as far as we know. But it might not stop there, right? This is just the beginnings of what we're seeing with, governments paying subsidies either directly or, as you say, indirectly via their SOEs to entities which are established in other jurisdictions. What do you think the reason is for that approach to an economy? And why do you think that host countries host jurisdictions like the EU are objecting to this? I mean, isn't foreign investment just a good thing and you should basically just say thank you to China? It might be a naive way of putting it, but that could be one's ordinary upfront reaction, because after all, countries like foreign investment, don't they? So what's actually going on here? I wonder if you could say a little bit about that.
Yes, thank you for answering the question, and it's a little hard, but I'll try to answer. And I think the question of whether investment subsidies is good depends. Like it actually the EU itself allowed the foreign investment subsidies in around 1980s, and provided that it did not disrupt the EU's internal market. And from that perspective, it seems that the EU itself accepts this kind of subsidies to some extent, and it seems they didn't concern it as a bad thing at foremost. So, well, with the rise of China as a global power and the Chinese firms and the SOEs established bridges and participate in a lot of projects abroad, especially by the Belt and Road Initiative. And concerns are growing because they worries about this kind of company with subsidies, and they may undermine the competition in the countries into which they expanded, and due to the support of the government, and especially when this kind of, and as you mentioned, the most crucial question, that white states, white countries intend to cultivate measures against that kind of country. I think one of the most important things is the concerns about when this kind of investors and they go into the host states with subsidies and they participate in the strategic projects, especially concerning some with the national security concerns, which may raise doubts on the security or the strategic development of the state, and that's where the countries care much. And well, from my perspective, it still depends on the further development of this kind of rules on foreign investment subsidies. Actually, so far there's no except the EU proposal, and there's no specific rules on this topic, and the rules I mentioned, they cover both trade subsidies and the investment subsidies, and it still depends on the further rules on how this kind of rules will take actions on their foreign investment subsidies, and how the cultivating measures of states should be regulated. Although they may not be under the multilateral framework in WTO, like the ASEAN agreement, but it still can be coordinated in some way. Thanks.
Okay, well, thank you very much. I have to apologize to people whose questions we didn't get to, but it's a good thing to know that that these presentations sparked the questions which I see before me, but that's life. Hopefully you'll get a chance to figure this out. And thank you all for your contributions. I'd like to conclude this session by thanking our two presenters, Joel Slawotsky and Keer Huang, for some really stimulating presentations. And I'd like to commend them also, if I might, for grappling with some really current issues. I mean, we're really talking about issues that have become present in the last year, probably, I think. And that is, of course, exciting for an international lawyer. We don't just try and thrash out ancient problems, but we you know, get excited when we can see that the work that we're doing is up to date and current. And who knows, maybe even helpful to governments, who of course are still the architects of international law. This is how it all works. So thank you very much. Congratulations again for your stimulating papers. It's a great way, I think, to spend a Sunday afternoon and evening. Now, we are just a couple of minutes overdue, and I hope that that has given us time. I see the participant count is rising, as one would expect, for a final speaker of the conference keynote speech being given by Professor Ernst Ulrich Petersmann. I am really very pleased to be able to introduce Professor Petersmann to all of you. I first met him, and I don't expect that he will remember this, but I first met him when I myself was a mere humble PhD student at the European University Institute about, in fact, even more than 20 years ago. At that point, already Professor Petersmann was an eminence and well known, and it was a great pleasure to speak to him. And he was also very kind, I should say. And that is not something that one always finds. Sometimes people, when they achieve eminence, want to speak only with other eminences. And it's a real credit to Professor Petersmann that he took the time actually to speak to me. I remember it well today. And in fact, I hope that I do some of this myself sometimes. It's a constant project, I think. And not only is he a great academic, but he is also a fantastic teacher. That's equally important in our line of work, and a presenter as well. And so let me come to some of his accomplishments and then say just a little bit about what he'll be speaking to us about. I'm sure everybody knows quite a bit about Professor Petersmann's background, but for those of you who don't, and it's always good to have a refresher, he is recently emeritus professor from the European University Institute, just outside of Florence. But this follows a very long and impressive and storied academic career as professor of international law, also of European law at a variety of universities, St. Gallen, Fribourg, Geneva, the Graduate Institute in Geneva as well. And of course, he has also taught at other prestigious institutions, including the Hague Academy of International Law, the Germain Academy of International Law, the EUI's own Academy of European Law, many other universities as well. He's extremely well known, and his career has stretched across many decades. He's of course published widely in areas of international European law and trade law. And I have to say a word about that because that's of course my own field, and that's where I came to know of Professor Petersmann's work, which is really quite pioneering. In particular, I think he gets credit for being the first person to make the link in international law terms between trade law and human rights law. Now that has really kicked off, and what we have in Professor Petersmann is someone who is responsible for really sparking off this field. I mean, I think it is probably a field by now. I myself have written a little bit on this, but I think it's fair to say we wouldn't really be anywhere without his pioneering work in thinking through how one can combine an area of law which is, let's say, in some ways traditional, state-centric, on the one hand, with what is really going on. And what is, of course, really going on is this, the economy, which is being regulated by trade law, of course, is not organized by state. It's not, it's not state-owned by and large. It is it takes place via private actors, and international economic law, seen this way, is really designed and should be designed to help private actors operate. And so what we have here is, you'll notice from I already made this link from Joel Slawotsky's talk earlier on, is a connection between different levels of law: international law, constitutional law as well, which is in large measure devoted to the protection of individuals, and other areas of law which are also focused on individuals, including international human rights law. Now, it takes a great mind to be able to bring these different levels of law together in a way which makes sense, which is coherent. And in fact, one might wonder why the areas of law are separated in the first place. Well, there are institutional reasons for that, but the work of academics is to make systems and to make sense of areas of law which themselves seem to, for institutional reasons, spin off into their own worlds. And I think we're going to have a great presentation on this. So let me now, I think I've said enough by way of introduction. We want to get to the meat of today's presentation. So let me hand over to Professor Petersmann, who is going to be speaking to us on this sort of topic. The title of the presentation is Multi-Level Governance of Public Goods. In fact, it's polemic. It's not just a statement, it's an assertion, which is great, and I think is an indication that we're going to be hearing something fiery. Multi-level governance of public goods requires multi-level, democratic, and republican militant constitutionalism. Well, there are a lot of words there which will keep everybody pretty stimulated, I think. Let's see what it's all about. Professor Petersmann, I hand the floor over to you.
Thank you very much, Laurent, for your very kind words of introduction, and good afternoon to all the others. Let me start by thanking the conference organizers for their invitation to close this conference with a keynote speech on my own paper and on the other conference presentations more generally. My paper differs from the other papers by offering a macro analysis rather than a micro analysis of how global governance of the Sustainable Development Goals can be improved. The title of my paper is a little bit too long, as Laurent rightly criticized. Multi-level governance of public goods requires democratic and republican militant constitutionalism. And my presentation focuses on essentially two claims. First, an empirical claim that the UN system and the WTO governance system do not effectively protect human rights and sustainable development. So yesterday morning, when Dr. Rao began his keynote speech by proposing reforms of the Security Council and of the rule of law system of the UN Charter, I asked the question, but how do you want to implement your proposal if the UN Charter provides for veto powers to block any serious reform of the UN Charter? And certainly Russia and China and the United States will not agree to any limitations of the veto powers. We had a similar problem in the Uruguay round negotiations from 1986 to 1994, where the result was dozens of additional agreements, but it was obvious these agreements could not be integrated into the old GATT agreement. So here again, the innovative response was to create a new organization, the World Trade Organization, to terminate the old GATT and thereby to indirectly force practically all the world, 164 WTO member countries, covering more than 90% of world trade, to participate in this very new WTO organization. So the point is that if you want to improve the output legitimacy of the UN or of the WTO, you have to improve its input legitimacy by more inclusive governance, by more citizen-driven, democratic and republican constitutionalism, as we see it slowly emerging in climate change governance and in citizen-driven climate litigation, holding governments more accountable. My second claim is a normative claim that international law among states cannot protect human rights and sustainable development without multi-level constitutional guarantees of human rights, democratic institutions, and judicial remedies. The Russian wars of aggression in Ukraine illustrate now that democratic constitutionalism can survive only as militant constitutionalism if citizens assume democratic and cosmopolitan responsibilities and struggle for protecting their human rights. I shall limit my talk to about half an hour, and I should be glad if we can use the rest of the time for some questions and answers. So most of the presentations we heard yesterday and today acknowledged that UN law and WTO law fail to protect human rights and sustainable development effectively. Russia's wars and war crimes in Ukraine, global climate change, biodiversity losses, international food crisis, health crisis, cyber wars, cyber criminality, disregard for international adjudication, failure to enforce international criminal law and prevent armed conflicts, there is a ubiquity of government failures and constitutional failures in international relations. And only few governments and academics ask the why question. Why are UN and WTO law not effectively protecting sustainable development goals? And even less people address the how question. How can UN and WTO law be transformed into more effective governance systems? Now, this question of how to protect public goods demanded by citizens has been studied for more than 2,500 years. In the ancient Athenian democracy, 2,500 years ago, the answer was protection of public goods depends on defending principles of democratic constitutionalism, like citizenship, democratic governance, mixed government, and courts of justice. In the ancient Roman Republic, 2,500 years ago, the answer was focused much more on republican constitutionalism, like separation of power, rule of law, and the Roman jus gentium, the Roman commercial law system. Yet both democratic constitutionalism in ancient Greek city-states and republican constitutionalism in ancient Italian city republics were later overthrown by power politics and empires, just as today democracy in Ukraine risks being destroyed by Russian tanks and military aggression. English common law constitutionalism evolved over centuries and focused on parliamentary and judicial protection of fundamental rights and property rights against abuses of feudal powers. Yet this common law constitutionalism did not prevent feudalism, it did not prevent colonial power politics suppressing human rights, and it also did not prevent the Brexit denial of European public goods like the European Common Market, the EU Charter of Fundamental Rights, and the protection and its protection by the European Court of Justice. The American and French democratic revolutions in the 18th century initiated constitutional constructivism, leading to the progressive adoption of national constitutions, mostly written, sometimes unwritten, by almost all 193 UN member states. Yet we know having a national constitution does not prevent an authoritarian government to suppress human rights at home and abroad. And we also know that US President Trump's big lie on the federal election results of 2020, his attack on the US Congress in January 2021, his climate change denial, his withdrawal of the United States from multilateral UN and WTO agreements are just another empirical demonstration that constitutional nationalism, also in the United States, cannot protect international public goods like climate change mitigation or international rule of law without extending democratic constitutionalism to multi-level governance of international public goods. So it is important that UN law and the UN Sustainable Development Agenda do recommend human rights, democratic governance, rule of law, and other constitutional principles for multi-level governance of public goods. Yet, in legal practices, these UN rules and recommendations remain ignored by many authoritarian governments, as illustrated by Putin's wars of aggression. And it is this empirical lack of legislative implementation, administrative and judicial implementation of UN and WTO treaty rules on human rights, rule of law, and sustainable development, which explains our collective failure to limit the ubiquity of market failures, governance failures, and constitutional failures, undermining the Sustainable Development Goals. And this brings me to my second normative proposition. In order to improve UN and WTO governance of public goods, we have to extend democratic and republican constitutionalism to multi-level governance of transnational public goods, notably by strengthening participatory democracy, deliberative democracy, and human rights, as we see it in European human rights law and in European and UN environmental law and governance. Now, constitutional nationalism is based on what John Rawls called a four-stage sequence of democratic struggles of citizens as reflected in the history of the US Constitution. In the first stage, reasonable citizens agree on their constitutional principles of justice, for example, in the US Declaration of Independence. In the second stage, the citizens elaborate a national constitution providing for basic rights and legislative, executive, and judicial institutions mandated to protect these agreed principles of justice. In the third stage, democratic legislation must constantly implement and protect the constitutional principles of justice for the benefit of citizens. And in the fourth stage, the agreed constitutional and legislative rules need to be applied and enforced by citizens, administrative institutions, and courts of justice, so as to protect equal rights, rule of law, and rule compliance by citizens. Now, this model of constitutional nationalism has become completely outdated, and most constitutional lawyers simply refuse to acknowledge it, unfortunately. Why? Because globalization has transformed most national public goods into transnational public goods, like most sustainable development goals. And no state in the world can protect these global international public goods unilaterally without international law and multi-level governance institutions. Also, the United States or China cannot protect international rule of law or prevent climate change or protect the environment without international law and multi-level governance institutions. So constitutional nationalism must be supplemented, must be complemented by some kind of multi-level constitutionalism as it has evolved in European integration law. So beyond this four-stage national constitutionalism, we need a fifth stage where international treaties for global public goods are negotiated and implemented in domestic legal systems. We need a sixth stage where multi-level governance institutions are constitutionally justified and controlled by citizens and their democratic institutions, as it is successfully done in European constitutional law. But we all know that neither the UN legal system nor the WTO legal system have effective parliamentary institutions, have effective judicial institutions. The intergovernmental cooperation is blocked easily by veto powers, and the executive powers of the UN and of the WTO are far too limited. So this need for incorporating and constitutionalizing multi-level governance of transnational public goods is completely ignored in authoritarian states like Russia or China. And at the seventh stage, we then need multi-level implementing legislation. For example, we just discussed subsidy rules, we need competition rules, we need environmental rules, we need social rules, limiting market failures and governance failures. And these rules must be enforceable by citizens and by multi-level administrative and judicial institutions. So just as a circular economy is crucial for sustainable development, we need some kind of a circular democracy where citizens and democratic institutions assume responsibility both at the democratic and at the cosmopolitan level, and where citizens and democratic institutions ensure the accountability of governance institutions and remain the democratic motor of the development of international law. Now, let me avoid misunderstandings, because what I just said may appear very academic to you, but I have always combined 45 years of academic teaching with more than 40 years of legal practice, both in the national and the European and in the worldwide UN and WTO institutions. So the first point is democratic constitutionalism is about protecting reasonable disagreement among citizens and among peoples. So multi-level constitutionalism is not about uniformity. It is about protecting legitimate diversity. All national constitutions differ from each other. All treaty constitutions differ from each other. And this reflects the diversity of individuals and of people. And at each of the proposed 8 stages of constitutionalizing law and governance, people remain free to take very diverse value decisions, for example, on how to incorporate treaty rules into domestic legal systems. So the reality of constitutional pluralism, the reality of disagreement about human and constitutional rights, the reality of regulatory competition, all this must be respected. Multi-level constitutionalism can only be built on what John Rawls called an overlapping consensus among people who will always continue to disagree on many political, economic, and social and cultural issues. This regulatory competition may promote positive synergies, for example, among EU member countries, among European Free Trade Area countries, among Brexit Britain, or among North American countries. But we also must admit that the increasing geopolitical rivalries with authoritarian states undermine UN and WTO governance. The adoption of formal constitution has not prevented Russia or other authoritarian states from suppressing human rights and democratic constitutionalism. American neoliberalism has destroyed the WTO dispute settlement system in order to avoid legal accountability for US foreign policies and for US industrial policies. And the US-China trade war and the collective sanctions now against Russia's war crimes will further deeply disrupt the global trading system. So the future of global governance depends on the impact of this increasing economic disintegration among authoritarian state capitalism, business-driven Anglo-Saxon neoliberalism, Europe's ordoliberal economic constitutionalism, and third world conceptions of economic regulation. And I have just published last week a new book with Oxford University Press on transforming world trade and investment law for sustainable development, where I argue that the globalization paradigm will become outdated, unfortunately, because this regulatory competition between very diverse regional economic systems and regional political systems will increasingly disrupt the WTO system and the UN system. But of course, climate change and other sustainable development goals require further global cooperation. And here I think it is important to recall that European integration law has successfully transformed this national four-stage model of constitutionalism into multi-level constitutionalism and has transformed international law into European community law, empowering citizens in multi-level democratic and judicial institutions. But of course, European integration law is a very imperfect system. So we have seen the emergence of illiberal EU member states, for example, in Hungary and Poland. And this confirms a more general point. The normative pull of human rights depends on their normative push by citizens and democratic institutions. That is, the effective legal implementation of human rights through constitutional law, democratic legislation, administration, judicial remedies, international treaties, multi-level governance institutions, secondary law of international institutions, and their incorporation into domestic legal systems. This is a dynamic process whose effectiveness and legitimacy depend on we, the citizens, democratic institutions and citizens struggling for their human rights. Now, another important lesson from European integration, I think, is that the most important result of 70 years of European integration has been 70 years of democratic peace among now 27 EU member states or 31 member states of the European Economic Area. And also in the external EU relations, EU constitutionalism, like the requirement in Articles 3 and 21 of the Lisbon Treaty that the European Union must promote its internal constitutional principles of human rights, democracy, rule of law, and sustainable development, also in the external relations. This has enabled the European Union to become a driving force for strengthening international rule of law and human rights in multi-level governance of the Sustainable Development Goals. Let me give you just two examples. The European Climate Law, approved in June last year, and the 13 legislative EU Commission proposals for transforming Europe into the first carbon-neutral continent by 2050, offered leadership inside and beyond Europe for implementing the Paris Agreement on climate change mitigation. Similarly, following the illegal destruction of the WTO appellate body system by the United States in 2019, it was the European Union to initiate a new plurilateral WTO appeal arbitration system based on Article 25 of the Dispute Settlement Understanding, now accepted by more than 50 WTO members. And the struggles of the citizens in Ukraine to defend democracy against Russia's aggression is another illustration that constitutionalism can effectively protect human and constitutional rights only as a dynamic struggle of citizens defending their rights. This empirical finding is consistent with the normative finding of Immanuel Kant in his constitutional theory about eternal peace more than 200 years ago, that international law among states cannot, neither empirically nor practically nor theoretically, protect human rights and rule of law inside states or in the relations between states and foreign citizens without guarantees of human rights, democratic institutions, and of rule of law. So the COP26 at Glasgow last year demonstrated how climate governance is becoming increasingly citizen-driven and science-driven. Yet, if we are realistic, we must admit that the lack of US support for constitutional rights or human rights to environmental protection, the lack of US support for carbon taxes, the insufficient commitments by China and India for phasing out of coal-based energy production, and the inevitable disputes which will arise when the European Union will unilaterally introduce carbon border adjustment measures as of next year, that all these potential conflicts and deficiencies in climate change governance will lead to a lot of future problems, conflicts, and as predicted by the United Nations, 140 million climate refugees by 2050. Now, it is easy to understand why authoritarian governments resist the proposition that constitutional nationalism must become embedded into some kind of transnational, cosmopolitan constitutionalism, empowering citizens to hold multi-level governance institutions legally and politically accountable. But I find it much more difficult to accept and to understand why most international lawyers and diplomats continue ignoring this constitutional insight that national constitutions and international treaty constitutions among states can never effectively protect human rights and sustain the sustainable development goals unless citizens are also protected and empowered to hold governments accountable and to protect human rights beyond national frontiers in multi-level governance. European integration law and its progressive extension to more than 30 countries over the past 30 years clearly demonstrate that it is possible. It is not a utopia. It is possible that to transform international law into community law, protecting human rights, democratic peace, and sustainable development goals. This is a reality in Europe, even if it is imperfect and fragile. And in order to change the output of UN WTO policies, we have to change their input by promoting democratic participation, social adjustments, accountability, and of course, much more social justice in the world, as it is progressively emerging in transnational civil society support for the climate regime. The annual COP conferences in the UN and the EU's new Green Deal have become inclusive collective learning processes, but this cannot be said for the WTO public fora, which have not changed intergovernmental power politics. So this brings me to the title of my presentation and to my conclusion. Democratic and Republican constitutionalism can protect multi-level governance of public goods, yet such protection requires what I call militant constitutionalism, militant democracies. It is a historical fact that most constitutional democracies emerged from internal civil wars or from external anti-colonial wars in order to overcome abuses of power. And the heroic self-defense of the people of Ukraine against the Russian aggressor is a reminder of this need for democratic struggles against internal and external enemies. So why is it that the number of democratic governments is declining and the number of authoritarian governments is increasing? Why is worldwide and regional adjudication increasingly disregarded not only by authoritarian governments, but also by the United States and by Brexit Britain? If globalization requires transforming constitutional nationalism into some kind of multi-level constitutional politics, then citizens, national parliaments, courts of justice, civil society inside UN member states must assume much more responsibility for protecting and implementing UN and WTO commitments to sustainable development and rule of law. We must all be grateful to Greta Thunberg and similar civil society struggles for defending our democratic values. And we must do everything possible to hold the war criminals in Russia and in so many other UN member states legally more accountable. Institutionalizing public reason remains a task of Sisyphus. That is, I don't know whether you all are familiar with Sisyphus, the tragic Greek figure who was condemned by the gods to push a stone uphill, even though the stone always fell downhill. But we know from the French philosopher Albert Camus that Sisyphus had reasons to continue his never-ending struggle to push the stone uphill. Just as democracies can survive only by defending human rights against tyranny at home and abroad. Thank you for listening to my concluding speech. I hope I provoked some of you, and I hope we can use the remaining time for a constructive, perhaps heated discussion. Thank you very much for your patience.
Well, thank you. That was just as stimulating and even provocative as I knew it would be, and a very, very enjoyable presentation. Thank you very much. And I might just say before I get to the questions that it takes some stamina to be Sisyphus, and you've certainly shown stamina. So, you know, these values don't exist on their own. They need to be promoted. And I think you've done some pretty impressive and well-known work in doing your bit to make the world a better place, really, if I can put it that way. Now, let me come to our questions. So we have a question, first of all, from Isibor Aigbe Oyakinan. I hope I'm not mispronouncing that too badly. I'm sure that I'm mispronouncing it somewhat, but apologies for that. Isibor works at the Central Bank of Nigeria as a legal officer and asks the following question: what should we expect of global governance institutions such as the United Nations? Who must hold multi-level governance institutions and their limited constituted powers democratically and judicially accountable? Which is yet another level. I think that's an excellent question. Let's deal with that, and then we have another question after that.
Thank you very much for this question. Let me say that I think we have to be very grateful to the United Nations for doing all the work for climate change governance, which the United Nations is pushing forward. So, but as I said before, this work remains insufficient for preventing climate change, and it probably remains insufficient for preventing 140 million climate refugees by 2050. So here the problem is, as I try to explain, the non-implementation of the UN recommendations and UN proposals by so many UN member states through legislative, administrative, and judicial remedies. So we must do what we do inside constitutional democracies. We must do what Greta Thunberg is doing. We must protest on the streets. We must protest in the universities. We must organize conferences like yours, where we try to discuss and educate people. And we must hold our parliamentary institutions accountable. Parliament should put much more pressure. We must go to courts. And in Europe, we see a very encouraging number of climate litigation cases where national courts condemn the German government, condemn the Dutch government, condemn the French government for doing too little too late. And where courts prescribe that the governments must change their climate legislation and must introduce much more ambitious greenhouse gas reduction commitments. So this is a struggle for justice, but it is a struggle for our own existential survival. And a world with 140 million climate refugees is probably not a very pleasant place. So here I think we have to assume democratic responsibilities. We have to assume cosmopolitan responsibilities, and everybody of us. And we have the institutions, democratic institutions, judicial institutions for holding governments accountable. Thank you for the question.
Thank you very much. Let me move then to a second question. This is Josefa Franke from the Hans Bredau Institute in Hamburg in Germany. The question is as follows. What are your suggestions for the design of a more participatory global governance? Do you see the EU as a role model, or would you go beyond? Are there any existing practice models on a more local level that you are aware of and that might serve as role model for a new ordering of global governance?
You know, I'm a European, I'm a German who was born after the war and who asked himself, how was this Nazi dictatorship, how was the Holocaust possible in a country which had produced a very large number of Nobel Prize winners before the First and Second World War. And I think the transformation of Germany after the Second World War was quite successful. And I already said that the transformation of the centuries of wars among European states through European integration law was also, I think, quite a big success. But these are, of course, European perspectives, and we are all different. And people in Asia, people in Africa, people in Latin America, people in North America have very diverse constitutional traditions, preferences, cultural traditions. So as you all know, China, with its 4,000, 5,000 years of civilization, has a Confucian tradition which never promoted this Western individualism, this focus on individual rights, judicial remedies. This is a different culture. So I think there are many ways for engaging civil society, for promoting government accountability. But I think the core problem is the lack of constitutional checks and balances in authoritarian states like Russia or China or others. So if Mr. Putin can unilaterally decide to wage war against not only a democracy like Ukraine, but to wage war against the European and UN legal and a peace system, that is a tragedy for the whole world. And this tragedy is due to the fact that you have no checks and balances in Russia. Russia has a wonderful culture, a land full of world famous composers and writers, but there is no democratic checks and balances whatsoever. And the government and the oligarchs in China are completely corrupt, completely corrupt. And here, I think there are many ways of promoting different kinds of democracy. So I think the European democracy focuses very much on constitutional rights, human rights, multi-level democratic institutions, judicial institutions. We will never see something similar in North America. The American conception of democracy is very different. So it is not a question of right or wrong. It is a question, as explained by John Rawls, that citizens agree among themselves on their own constitutional principles. And these constitutional principles in North America will always be different from those in Europe. And in Asia, they will always be different from those in Europe and in Africa. They have their own traditions. So uniformity is impossible and is not even desirable because we are all different and we all have different moral beliefs and we don't want a straitjacket. But so the answer to my question, to this question would be, I think there are very diverse conceptions of constitutionalism, of democratic governance, of republican governance. And this has always been so. That's why I started with the Athenian model, which was very different from the Roman republican constitutional model. But if you ask, I've taught a lot at universities in India or in China, and I always ask the local professors, do you have examples in India or do you have examples in China similar to the Athenian democracy 2,500 years ago or to the Republican constitutionalism in Rome? And the answer is usually no. But these are different traditions. This is not about right or wrong. This is about citizens agreeing on their own principles of justice. And we have the capacity. Citizens are very complex human animals with a lot of rational egoism, with a lot of passions, but we have all a certain amount of reasonableness. And constitutionalism is a response to the bounded rationality of individuals. Tie your hand to the mast in order to limit your passions, in order to limit your weaknesses, your animal instincts. Unfortunately, nobody has bound Mr. Putin to the mast, and he is just unilaterally deciding to destroy democracy with 40 million citizens. And that is something we should really avoid.
I think that's an excellent reflection that we can close on. Thank you very much. Thank you to those who asked the questions. There were a few more, but we have now reached the end of our time, unfortunately. Let me thank Professor Petersmann once again for a very stimulating presentation, for engaging with the questions, which I also thought were extremely well targeted and a great way to finish off what has been a stimulating conference. That's it from me. I would now like to hand over to the conference organizers, Tejas Rao and Jane Jin Kin, to close out the conference. Thank you for your participation, everybody. This is really what conferences are about, so it's great. There were so many people tuning in and hopefully enjoying and being educated by the presentations over the past 2 days, but the ones that I've been involved in this afternoon and evening. Goodbye.
Thank you, Professor Bartels. Now we are at the end of the 11th Annual Cambridge International Conference. Thank you very much for spending your weekend with us. I hope you have had an informative, engaging, and interesting feast of thoughts. This conference would not have been possible without the support from our distinguished keynote speakers, our amazing chairs and authors, as well as the hard work of the conference team, Apruva, Jameson, Ross, Toba, George, and of course, my co-convener, Tejas. Our special thanks to the audience. Your presence really enlightened the discussion.
While we were sad not to have met you in person this year, the conference has been a resounding success for us, with over 850 unique viewers from around the world for 8 panels over 2 days, with more to come when the recordings are uploaded to YouTube. Our thanks also go to the editorial board and the editors-in-chief of the Cambridge International Law Journal, Darren Peterson and Oliver Hales, for their trust and support over the past few months. We would also like to thank our predecessor, Ms. Rebecca Brown, for her meticulous handover notes, and all those who convened the conference before us for their generous words of advice. We are grateful as well for the deep, continued partnership with the Lauterbach Center for International Law, whose fellows so graciously contribute their time to this conference and the journal each year, as well as Edward Elgar Publishing, who continue to offer a discount code to all participants. Please check the final version of the program for further details. Finally, as was indicated during the opening ceremony yesterday morning, the call for papers for volume 11.2 of the Cambridge International Law Journal will be out next week. We encourage all panelists, presenters, and participants to submit their papers for consideration. Volume 11.2 will be published in December. We look forward to hosting you again next year, hopefully in person in Cambridge. Have a lovely rest of your weekend, and thank you again.
Bye-bye. Thank you very much. Congratulations for your enormous efforts.
Thank you so much.